All right. Good afternoon, ladies and gentlemen, and welcome to today's webinar hosted by the East Africa Law Society. We are delighted to have you join us for what promises to be a very thought-provoking discussion on a topic of immense importance, particularly in light of the current global developments in the Middle East. Our theme today is on strategic extractive contracts, driving sustainable development and long-term value in Africa. And as we all know, extractive resources are typically invested in the state, and yet there are a number of challenges that states face in accessing risk capital and technical expertise necessary for exploration and development. And this has necessitated partnerships with international and domestic companies, which are governed by a number of legal instruments and contractual frameworks that define their rights and obligations. The extractive sector is fraught with a lot of physical, commercial, and political risks at various stages, and usually discovery does not automatically translate into commercial viability. And we have very many examples in history that reminds us of the volatility of the extractive sector, especially in the oil and gas sector, as you can see in the current Iran war and the other global crises. Against this backdrop, today's conversation will explore how strategic extractive contracts can be designed to deliver sustainable development and long-term value for Africa. And it is my pleasure to introduce our distinguished panelists who will guide us through this discussion. Our keynote address is Professor Qureshi Hawar, who will give the keynote discussion in the topic on stabilization clauses. He will be joined in the panel by Dr. Carol Knuckle, who will discuss how governments effectively negotiate stabilization clauses and fiscal clauses to ensure long-term value from extractive resources. And finally, we'll have Dr. Victoria Nalule, who will discuss with us how governments mitigate legal, environmental, and commercial risks in the extractive contracts. Ladies and gentlemen, we are honored to have this very diverse and extremely knowledgeable panel with us today. And I urge each of you to make very good use of the Q&A session to be very interactive, post your questions on the issues of discussion today. And so without further ado, it's my pleasure to welcome all of you to this webinar. And because of the tight schedules of our speakers today, I'll request Professor Qureshi to come in straight away and give us his keynote address. Welcome, Professor.
Christopher, thank you very much, ladies and gentlemen. It's my pleasure to join you. I want to thank the East Africa Law Society and the many hundreds of you who have signed up for this webinar to discuss an issue that I've been dealing with for the past 35 years. I begin with an apology. I'm actually in Paris at the moment. It's nice and sunny, and there's a wonderful gentleman, Osama, who's taking to my destination. The train was ever so slightly late, and that's why you see me it might be a little bit bumpy, so we're going to be talking about stabilization clauses, but the road might not be so stable. No fault of the Parisians. We're talking about extractive industries in Africa. Within the context of my 35 years of practice, some of you may know that I've acted for or against many African states. I've acted on oil and gas disputes in West Africa, in East Africa. I've acted on mining disputes in Africa, gold, nickel. I've acted on mining disputes relating to copper. I've done oil and gas disputes in the Middle East. We have an office in the Middle East where my colleagues are at the moment. I'm not making any political points, but the situation is an appalling situation, which is getting worse and worse, for which there seems to be, I'm not making a political point, absolutely no legal justification. And we therefore have to look at the situation of extractive industries from the perspective of law and protection of the rights, not just of the investor, but also of the state. We've seen all too often over the past 6, 7 decades how, in many states in North Africa and in Africa, Central Africa, Eastern, Western Africa, the rich resources have not necessarily led to a, a transfer of wealth, let alone a transfer of knowledge. And if I am to try to give you an insight from my practice, what I found is as follows. Uh, the foreign investors are obviously first and foremost concerned about the uh, return on investment, and they seem to achieve a much more spectacular return on investment in Africa than in many other locations. And that might be partly because they consider, rightly or wrongly, that the risk elements are greater: political risk, security risk. Of course, we must remember that the uh, simply finding uh, oil, gas, natural resources isn't the end of the matter. Uh, there are vast resources that are required for extraction. In many situations, the deposits that exist, it's not feasible to extract them because the cost of doing so and the inability to be able to transport them in a market which isn't necessarily commercially viable leads to them not being extracted. But we know at the moment that Africa is increasingly of interest and concern for extractive industries, also for other natural resources. We've seen some rather unfortunate situations. Many of you may know that Tanzania is on the receiving end of at least half a dozen claims by foreign investors. These claims are being brought with regards to mining exploration licenses, and the government is on the receiving end of potentially billions of dollars of liability. We can only hope from the government's perspective that the claims are dealt with and resolved successfully. But of course, let me look at this from both perspectives. I mentioned the investor, and the investor, rightly, if they're to allocate resources for extraction, expects a return on investment. And what they expect in return is a stable legal framework to be treated fairly. How does that arrive? Through the contract? The contract will contain mechanisms. There will be an applicable law. Quite often, the applicable law is English law, and many of the states, certainly in East Africa, find the reference point in the common law in English law. So far, so good. In East Africa, in Uganda, Kenya, Tanzania, you have an extremely well-developed body of jurisprudence. I've had the good fortune to appear in the courts in Kenya about 5 years ago on a fairly large-scale matter for the state. I understand very well-developed jurisprudence and a judicial bench that strives to achieve effective dispute resolution. You've got your applicable law, which provides protection. The normal framework of contract provides protection. You have uh, the normal provisions relating to breach of contract, damages as a matter of common law. And then on top of that, of course, you have investment treaties. Investment treaties have been in existence since 1959. And what they provide a foreign investor is protection against two fundamental types of activity by the state or others acting on behalf of the state. Unfair and equitable treatment means allowing the investor to come in where he or she has a legitimate expectation that the legal regulatory framework will not be changed, and then soon after imposing additional taxes, imposing additional environmental requirements, which make the investment unworkable or commercially unviable. And the second, which doesn't happen as often as it used to, is expropriation. The extreme form is taking of assets. The state sends in its people to remove the foreign investors' personnel and physically takes over. That's unlikely. It doesn't happen as often as it used to. It did happen in South American places such as Venezuela in 2006, 2007, where the state purported to nationalize the assets, and you had various foreign investors, principally American oil majors, who alleged that their assets had been unlawfully seized. And if you listen to what Mr. Trump says, unfortunately, whether we like it or not, we have to listen to him. Some of the justification that he gives for what is being done in Venezuela is to, quote unquote, to provide redress for those American oil majors whose assets allegedly were taken in 2006, 2007. So that's expropriation. These foreign investment uh, uh, claims, investment treaty claims, are generally brought within an international framework called ICSID, which has been in existence since 1966, the International Center for the Settlement of Investment Disputes. Sits in Washington, but the arbitrations take place in numerous jurisdictions or under uh, arbitrations pursuant to the UNCITRAL rules, either 1976 or 2010. So bear that in mind. The arbitrations tend to be seated in jurisdictions that parties are comfortable with on the basis that the courts will provide support. And that tends to be Washington, London, Paris, Geneva, and Singapore. Of course, we know that East Africa, is trying to ensure that there are there's proper regard for the potential in East Africa, not least the Nairobi International Arbitration Center, and that we can only hope that the offering in East Africa is taken up much more by the parties to disputes. What needs to happen is there needs to be more understanding of the support provided by the courts, the availability of logistical support, whether it's hotels, whether it's being able to travel backwards and forwards, whether it's translators, whether it's experts, hearing rooms. These are all part and parcel of what make a successful arbitration center, and we can discuss that later. But when we come to uh, extractive industries, obviously, again, I said I would try and highlight some of the key points. One of the key points that I have found in the course of my practice, having acted for states and against states, whether it's oil and gas or in the context of commodities, is a failure to effect due diligence. Due diligence, when we're looking at the state on the part of the foreign investor, who is the foreign investor? What is the track record in this particular sector? How is the foreign investor coming into the jurisdiction? Are they coming in through what's called an SPV, special purpose vehicle, which is a company that you more or less create overnight? Does it have any assets? What if the foreign investor behaves in a manner which is unacceptable or breaches its contractual obligations? What is the recourse of the state? Does the foreign investor have any assets? Is there a guarantee? Is there a parent company that is providing a guarantee? In terms of the resources that are being extracted, has the state carried out its own geological surveys? Does it actually have its own independent reference point? Or is it relying upon what the foreign investor is telling it in terms of the potential yield so far as the mine is concerned, or what might be recoverable vis-a-vis oil and gas? Where's the audit coming from for what's coming through? That's on the state side. And on the foreign investor side, what the foreign investor is concerned with is security, which is stability. Foreign investors, when they're investing in these projects, we're looking at a 10-year plus projection where the capital investment doesn't actually find its return until about year 10, and then it's profit after that. I've just done a very major case involving one of the biggest oil companies in the world against a state uh, in the oil sector. And I've also done a dispute 6 months ago concerning aluminium. And the investment is vast. So when you're looking at these contracts, whether you're looking at it from a state perspective or you're looking at it from the investor perspective, are the contracts commercially viable, whether for the state or for the foreign investor? Are they as future proof as possible? And that's where the foreign investor is concerned with what's called a stabilization clause. All the stabilization clauses are extremely important protections for foreign investors. Essentially, what they require for is that whatever the framework was when the foreign investment was implemented, it must be maintained. And if it changes, regulatory framework, tax framework, environmental framework, and the foreign investor perceives that it's acting to the foreign investor's detriment, then the foreign investor will make a claim that the state must make up the difference. So let's say if the profit was $10 million a year prior to a change in the tax law, and then the profit is reduced down to 6 million, the foreign investor will argue that the state has to make good the difference, which is 4 million. So stabilization clauses are extremely powerful. These invested treaties are also extremely powerful because whilst 20, 30 years ago, the consensus was if a foreign investor wants to make a claim, come to the local courts. The foreign investor doesn't have to do any of that anymore. The foreign investor can go straight to this arbitration, investment treaty arbitration, can obtain a decision against the state for many millions, if not billions. I've just done a case where the award was $50 billion, and then enforce that award against the state's commercial assets. And the commercial assets can be buildings, can be ships, can be airplanes, can be proceeds of sale of commodities. So it's a huge amount that they can gain. It's a colossal amount. So when we're talking about strategic investments, foreign investors, what I wanted to do is just to pause there. I see that I'm about to arrive, and I understand that there are panelists who are present for the discussion. If you'll forgive me, I'll enter and I'll continue online, but I'll go mute and I'll go off camera if that's all right. Christopher.
That's all right, Prof. We can have Dr. Carol, if she can hear us, to just come in briefly as Prof is doing the transition. Great to have you on board, Dr. Carol Lackland. Ladies and gentlemen, I introduced her in her absence, but I'll briefly just mention Dr. Carol is a globally recognized energy expert and thought leader with nearly 3 decades of experience in energy policy, markets, governance, fiscal regimes, and energy security. She's the founder and CEO of Crystal Energy, an independent, multi-award-winning advisory firm, internationally recognized for its strategic insights across the energy value chain. Dr. Knuckle has advised major energy companies, governments and parliaments, international organizations, and multilateral institutions, bringing rare breadth and depth to global energy market developments and the forces shaping the energy landscape. She currently serves as the Secretary General of the Arab Energy Club, Board and Audit Committee member of the Natural Resource Governance Institute, and lead energy expert at Geopolitical Intelligence Services. Her academic engagement includes lecturing and examining PhD research at leading institutions, including the University of Aberdeen, the Blavatnik School of Government, and the University of Oxford. Dr. Knuckle has an extensive publication record, including contributions to IMF publications, and is the author of Petroleum Taxation, Sharing the Wealth, and co-author of Out of the Energy Labyrinth with Lord David Howell, the former UK Energy Secretary, both widely cited in academia and industry. She's also a regular media commentator on global energy and geopolitical developments. She's a sought-after keynote speaker and moderator, and is known for combining strategic insight with exceptional facilitation skills. She's the founder of Access for Women in Energy, a freeman of the City of London, and a member of the Worshipful Company of Fuelers, and a fellow of the Energy Institute. Her honors include CEO of the Year, United Kingdom in 2021, and an Arab Women Entrepreneur in Energy in 2025. Thank you very much, Dr. Carol Knuckle, for being with us. It's such an honor to have you on board to be part of these discussions. And I'll invite you just to come in as Prof is moving in to talk to us on your lead topic of today, which is how governments can effectively negotiate stabilization and fiscal clauses to ensure long-term value from extractive resources. Welcome.
Thank you very much for having me, and apologies, I joined a bit late. I just got the timing wrong. I don't know why in my calendar it was showing 12 o'clock, then I got the alarm at 11 that, we're starting. So apologies for that. But I'm glad I was able to join you and to hear Professor Kawar's inputs and remarks, which kind of feed in into what I'm going to say. I've been in this field for many, many years, and even though we talk about always, like we look at the principles, what is the best thing, the ideal scenario for contracts, for fiscal regimes, and we always talk about stability. Stability is important because we're not talking, I mean, even if we're talking about something that you would invest today and you would get returns tomorrow, you still want to know what is going to happen between today and tomorrow, right? Even if you take it on a personal level. Let alone when you're talking about extractive projects, whether oil and gas or mining, these are projects that are for the very long term. And we're talking about easily 10, 20, 30 years. I know some oil fields, they have been producing since the 40s, and they are still producing large volumes of oil and gas since. So that's why we're talking about this long time frame. Stability becomes even more important because you want to put significant capital today, and we're not talking about few thousands or few hundred thousands, but millions and millions. So you want to commit them today, and you want to see how, as much as clearly as possible, how your returns are going to look like in the coming years and decades. And of course, there are lots of uncertainty that we have to face, even if everything else is okay, there will always be some kind of uncertainty. With extractive, that uncertainty is even higher. You have the geological uncertainty, you do have technical uncertainty. We don't know how technology is going to change. We saw, for example, how the share revolution in the US it took everyone by surprise. Nobody expected that just a small change in the technology was going to make the US the largest oil producer in the world suddenly within a matter of few years. Artificial intelligence today and digital technologies, we don't know how they are going to evolve going forward. The other level of uncertainty is prices. And you saw today, I mean, look at just what's happening in the Middle East. In 2, 3 weeks, we saw prices suddenly increasing by $40 a barrel. And if you join them, watch every day the changes, you can see up and down, up and down, up and down. So there is already a lot of instability out there. And there is another source of instability that actually can be controlled. That is policy risk. What governments, host governments can do to minimize that risk. So investors are going to allocate a certain return requirement for each kind of risk. But definitely, if they go to a country where there is high fiscal instability or governments changing their mind all the time, those investors are going to allocate a higher requirement to compensate for this additional risk than if they were to go to a country where there is greater stability. So, to give you an example, if you go to Norway, Norway has always put stability at the core of its policy, energy policy, fiscal policy, petroleum policy. And they can afford to charge 78% in terms of government take or marginal tax rate. But they do that because they know that whoever comes to their country know that that's going to be the take for the years ahead. But other countries who don't have the same stability, where policies are changing all the time and the fiscal terms are changing all the time, they cannot afford that high government take because investors are not going to be going there with a big smile on their face, especially if everything else is not attractive. So this is just in a nutshell to give you to share with you why stability is important. However, we know that even though we say that stability is important, is an important principle, we know in reality it is very difficult to deliver because things change. As I mentioned, geology can change. Look at Guyana. Nobody expected Guyana to suddenly start producing within a few years after it was completely overlooked by other players. I don't know if you heard, was it Shell CEO who said he regrets leaving Guyana after they thought that there was no potential there. So there is a geological situation can change, technology can change, market prices and structure of the market can change. So stability in reality is very difficult to deliver. But what governments can do, while we know that contracts and fiscal terms are never cast in stone, no matter how much we insist on stability. What governments can do is minimize the risk of instability or minimize the need to change. That's what I would like to say. I don't believe there is something called stability, but I do believe in the need for minimizing changes. So investors know, and investors are not unrealistic in their demands. No matter what they bring to the negotiation table, they may come and show that they are the tough guys and they have opportunities elsewhere, but they can also understand the requirements and the needs of the country and the constraints from a government perspective. But what investors want to know is that governments are not going to change their mind constantly. With every change in oil price, for example, governments are not going to change their minds as well. So this is where the concept of stabilization provision come into the picture. Personally, I don't think that is needed for several reasons. One of them is the fact that you do have, first of all, the sanctity of the contract. So when you enter into a contract, to an agreement between an investor and a host state, that by itself is protected. So governments should not go and change their mind suddenly. And also, if stabilization provisions were essential, they would have been offered everywhere, but they are not. So if you look at the developed economies in the OECD countries, I don't recall seeing them, maybe on rare occasions for certain specific things, but they are not offered there. If you were to sign a contract in the UAE, you're not going to be offered that. But if you go to many countries in Africa and other developing economies, you do find them more commonly spread. And that's why, if something is so essential, why it is not applied everywhere? Why do we find them solely and largely in some countries? What do those countries have in common? Well, I did a paper with a colleague of mine from the IMF, Mario Mansour, and that paper, I'll be happy to make it available. If you go on our website, Crystal Energy, and you look at the research, you will find fiscal stabilization, oil and gas contracts, and you can access that paper. But for now, I just want to keep it very simple. There are certain cases where we find stabilization provisions are more appealing. Typically, it's when we find governments are in a weaker bargaining position, not because we have bad government or poor government, but what makes them weak, for example, if they don't have large geological potential, if the investment is not well developed in the country, if the image of investment, not just in oil and gas, but overall, is one that is not appealing, that it's really unstable place to go into. So this is where governments feel that let us compensate for this negative image that we have and offer the stabilization provision because that improves our appeal. And also sometimes governments do it to gain a competitive advantage over, for example, their neighbor. Oh, my neighbor is not offering this and they have similar situation as our country. So what else can we do to win an advantage over my neighbor? I'm going to offer stabilization provisions. So this is where the case can be appealing for investors because they say, yes, we're not going to commit our capital and we're not sure whether we're going to get our capital back anytime soon, or governments is going to change their terms every time there's something change in the market that is not good for us. And governments feel that they are offering something that maybe will make investment in their country more attractive. However, when we investigated the effectiveness of those stabilization provision, we found that governments and investors put more faith into the effectiveness of these clauses than actually they are effective in reality. In other words, at the end, governments can do whatever they want. They are the sovereign owner of the resource. They are acting on behalf of the population. And even if you have those stabilization provisions and the contract that was signed was really unfair to the country, governments can go tear it apart and then sign new contracts. We've seen it in Venezuela, for example, under late Chavez. We've seen it elsewhere. So companies know that, and that's why not every time there is a dispute over those provisions, you end up international arbitration. Usually those disputes tend to be resolved amicably because many companies know that that is the nuclear option you enacted, if you take governments to international arbitration, you often have less opportunities in the country and you kind of break the relationship with the government. So what I investigated with my colleague Mario, we found that in around, I think, less just under 50 countries, that stabilization provisions, they tend to have the image of being great and being like giving you protection, but they are not the answer to your problems. They can provide some protection, but definitely not an absolute protection. On the contrary, what we found that is much more robust and much more effective is designing the contract to start with in a way that requires less negotiations later and have the fiscal terms properly designed from the beginning, that you don't need to revisit those terms should the conditions change. So whether you make a discovery or you don't, the terms can adjust automatically. Whether you make a big discovery or a small discovery, the terms adjust automatically. Whether the prices go up or down, the government share is protected. This is not guaranteed by a stabilization provision. This is guaranteed by a proper design of the fiscal terms and the contract. And that's why we say that the devil is in the details when it comes to signing contracts. So can you live without stabilization provision? Absolutely. And again, they are not offered everywhere. Do you need them? Not necessarily, but you can have them. If you decide to have them, then you have to be careful how you offer them. Whether you give them, let's say, covering everything, which is not really good for the government, or you can make them more targeted for a certain period and for something very specific. Then they can be more suitable for the government and for the investors. Some governments who offer them, they offer them as an option. So they tell the companies, you know what? You can have a stabilization provision, but if you would like us to commit to that kind of deal, then you have to pay a premium. So they end up, for example, say, yes, we're happy to do it, but instead of a royalty of 5%, then you pay 10% because you are paying for something that you think is valuable, that is stability, guaranteed stability in the contract. So yes, you can offer them, but be careful what you are offering. Just blanket, wide-reaching stabilization are not good. I'm happy to discuss what are the advantages of that. But again, the main message I want to leave you with is that it's not clear-cut, it's not good or bad. It is nice to have, but not essential. And we can live without it if we do something much more important, that is the proper design of the contract and the fiscal regime. And let me leave you on this note, but happy to discuss further later on during the Q&A session. Thank you very much.
Thank you very much, Dr. Nakul, for handling that very comprehensively within a very short time. And it's good to hear the insights from your practice and, in fact, your research on this contractual safeguards. I see in the Q&A we already have some two questions. Probably we can have this for you to react on, or Prof, if he's back, before we move to the next section. And I'll go to the first one by an
Sorry,
anonymous attendee. The question is, what happens in situations where the FDI contracts are entered into illegally? Yes, Prof?
sorry, forgive me. There's a little issue with the camera. But just coming back to Carol, I agree with her. She's absolutely right. It was the point that I was making. You've got to be realistic. If you want a long-term relationship uh, and a commercial relationship, it's got to be viable for both parties. On stabilization clauses, let me explain the rationale, the philosophical rationale. Whether it's right or wrong is another matter. And these are problematic provisions. The first time we had a dispute was concerning stabilization clauses was Texaco and Libya. This was in 1976, and there was an arbitration about the meaning of stabilization clauses. And as I mentioned, I've just done a case recently. The point is this: you have a tussle between capitalist states and socialist states. Socialist states, the natural resources are under the absolute control of the state, and it can do what it wishes with them. Then you have the capitalist state, where foreign investors, when they invest and they invest capital, they're entitled to protections. Stabilization clauses are essentially yet, as Carol pointed out, an additional layer, an additional offering where the state says, we might change the framework. We're not sure what's going to happen 5, 10 years from now, 20 years from now. And maybe we have to do it. And it's not targeting you, it's not discriminatory, but we will make you whole. We will make it good for you. And that's in context where you've got states that are not as developed, not as mature, and foreign investors want that additional protection. Forgive me, Christopher, I just wanted to give you that background in terms of the philosophical rationale for them. Forgive me. Thanks.
Thank you very much, Prof, for that addition. I see there are more questions we're receiving, but before we go to the questions, I know we have to release Prof. Qureshi and Dr. Knuckle because of other engagements, but I'll quickly invite Dr. Victoria Nalule to give a very short presentation, then we can have all the questions together. And by way of a brief background, Dr. Victoria Nalule is a dual qualified energy and mining lawyer in the United Kingdom and Uganda, and she's the CEO of NEM Energy, and a globally trusted strategist in energy, mining, and natural resources law and negotiations. She operates at the intersection of law, policy, investment, and geopolitics, advising governments, state-owned entities, development institutions, and private investors on structuring bankable, resilient, and future-ready energy and extractive projects. She holds a PhD in International Energy Law and Policy from the Center for Energy, Petroleum and Mineral Law and Policy at the University of Dundee, UK, and lectures in the Natural Resources Law at the University of Bradford. Her academic rigor is complemented by hands-on experience leading and advising on complex, high-value negotiations across emerging and frontier markets. Dr. Nalule provides strategic advisory services in extractive governance and regulatory reform, energy transition, and climate policy frameworks, as well as dispute avoidance, arbitration strategy, and energy disputes. She's a member and committee leader of the Chartered Institute of Arbitrators, the Scottish branch, a notary public, and an ICC YWF representative for Africa under the International Chamber of Commerce. Dr. Nalule brings strong international dispute resolution credentials and also serves as a recognized arbitrator at the Energy Disputes Arbitration Center, positioning her at the forefront of energy arbitration and cross-border dispute mechanisms. Her expertise has been sought by leading institutions including the African Union, African Development Bank, the International Energy Charter, Extractive Industries Transparency Initiative, to mention but a few. She's a prolific author of 9 books and numerous peer-reviewed publications. And Dr. Nalule has pioneered the energy progression concept, a negotiated, informed framework enabling resource-rich developing countries to pursue sustainable energy transitions while safeguarding socioeconomic stability and energy security. It is my pleasure to welcome Dr. Nalule on board to give us a presentation. Welcome.
All right, thank you. Thank you, Christopher. Maybe you could just remind the panelists the attendees what I'm talking about, what the question is about, my topic.
My apologies, yeah. Dr. Nalule will take us through how governments can mitigate legal, environmental, and commercial risks in extractive contracts. Welcome.
All right. Thank you very much, Christopher. And I would like to thank my fellow panelists, Dr. Carol and Professor Parker, for first accepting the invitation and also for your time and brilliant presentations. So they have already given us the background of what stabilization clauses are and why they're essential, or some of the risks that are associated with stabilization clauses. Basically, to start with, extractive industries, they're unique in nature. Unlike other projects like the agriculture sector or the transport sector, with extractives, first is for long term, like my colleagues have already mentioned, often the contracts or projects last for over 20 years or more. And then the other important thing is that the resources in most cases belong to the government, but the government is just holding them as a custodian for the citizens. So there is always that pressure for the government to ensure that first, it negotiates contracts that are going to be beneficial for the state itself, but also contracts that are going to be beneficial for the citizens. And then the other important thing is to ensure that the revenues from these resources can be utilized to ensure that there's development for that country. That's why when we're talking about a resource curve, most people would refer to countries that have resources, but they haven't been able to utilize them well. So what is the starting point before we even look at how governments can be able to utilize their revenues from extractives in an effective way? The starting point is the contracts that they're signing with investors. Because remember, since the resources belong to the governments, it's the government that is going to issue out licenses to the investors, international energy investors, international mining investors. So the starting point is, how exactly are you going to negotiate these contracts? Because we often talk about extractive contracts, oil and gas contracts, petroleum sharing agreements, concessions. But like Dr. Carol Nakla mentioned, the devil is always in the detail. So let me just take this opportunity to briefly share this contract on the Guyana resources, the Guyana contract, sorry. Can you see my screen?
Yes, we can see it.
All right, so for the attendees that haven't had a chance to really look at what is included in these extractive contracts that we're talking about, this is an example of the petroleum agreement between the governments of the Cooperative Republic of Guyana and Esso Exploration. So this is a 2016 contract, but I just want to draw your attention to the table of contents. Obviously, with the limited time we have, we're not going to go through everything, but my point here is each and every provision you see in this contract has to be negotiated well. If this provision, starting from Article 2, agreement, the operator, their liabilities, if they're not negotiated well, the government will either be losing a lot of money or the investor will be making lots of losses. And then each and every provision in this contract is capable of being the source of a dispute. Because when you're talking about stabilization clauses, contracts, the end result is if there are disagreements within this agreement, then they're always going to have disputes that have to be resolved through international arbitration, especially if the agreement has an arbitration clause. And like the example we're seeing here under Article 26, there is arbitration and applicable law. I'll not go into detail into what they really mention in these provisions, but here, this Article 26 is to the effect that in case of any dispute or disagreement within the contract, then the dispute has to be resolved through international arbitration. Then most importantly, there's this Article 32 on the stability of this agreement. So this would be the stabilization clause. And how the government and investors are going to negotiate the stabilization clause or Article 32 will determine whether the government and the team that is negotiating on behalf of the government has done a good job for the government and the citizens, or they're simply selling their resources. With stabilization clauses, you have stabilization clauses of a legal nature and stabilization clauses of a physical nature. So the legal stabilization clauses basically are to the effect that there shouldn't be any changes to the laws that are going to negatively impact on the investor's interest. And then the fiscal stabilization clauses would be stabilizing aspects like taxation and the entire fiscal regime. So how the government and investors are going to negotiate each and every provision in this agreement will determine whether the government and its citizens are going to benefit from the resources or not. For instance, with the taxation and royalty, if the team negotiating on behalf of the government decides that they only need 2% of royalty from their resources, the question is, would that be beneficial for the government and its citizens? No, it will not. But if they decide that, okay, the royalty will be like 40%, 50%, or 60%, the question is, are they going to benefit or they're not going to benefit? So all that it's in the detail of how exactly they're going to negotiate these clauses. And then you have another clause here on domestic supply obligations and also Guyana resources. These are the clauses that in most cases refer to as the local content provisions. How exactly are they being negotiated, especially for the developing countries that really want to ensure that their local people can benefit, get opportunities from these extractive projects, or that even the resources, local resources, can be utilized, because local content includes like first employing the local people and then also utilizing local services or even local goods. So all that will have to be included in the contracts. So in summary, I'm going to stop sharing, but for the people who haven't really had a look at what an extractive contract looks like, this is how it looks like. And then issues of environmental protection. Now we are seeing a lot of research is pointing to the fact that there is a lot of methane emissions from the oil and gas sector. So how are you going to negotiate environmental provisions or protection in the contract? Will it be the investor to pay for that pollution, or will the responsibility be shared between the investor and the government? So the starting point for the government, even for the lawyers and experts, is really to ensure that each and every provision of this contract is negotiated in a fair and sustainable manner. Otherwise, if we have unfair contracts, that's why you'll see that after a regime change, the new government will just decide to cancel all the unfair contracts that were negotiated by the previous regime. And then the investor would obviously look at the article they negotiated on the stability of the contract, Article 32, and then look at the article on arbitration 26 and bring disputes in international arbitration. But if we have a way of ensuring that the contents of these contracts are going to work for the benefit of the government, the citizens, and the investors, then the disputes will not be as much as we're seeing right now. But also, most importantly, like Dr. Karanakla mentioned, stabilization clauses in extractive contracts, they are mostly found in developing countries. Because we also did research for the EITI, the Extractive Industries Transparency Initiative, where we are reviewing different extractive contracts from across the globe, and we found that most countries don't offer these stabilization clauses, and they have been detrimental to the countries that offer them, and yet they're not a necessity, because besides stabilization clauses, there are other avenues of protecting investors. Most countries have investment laws. Most countries have provisions, constitutional provisions, that are against expropriation. Most countries, even within the contract, like the investments are already protected, even through the bilateral investment treaties, the multilateral investment treaties. So we have all these legal provisions and protection that are already available in these countries, in that the stabilization clauses are honestly not necessary. So moving forward, we have to ensure that as we're talking about how investors and the governments can protect themselves, they can mitigate the risks, the starting point is to ensure that you negotiate contracts that are going to be fair for the government, contracts that are going to be fair for the investor, but most importantly, contracts that are going to be fair for the citizens. And then how do we mitigate the legal, environmental, and commercial risks? Besides the contracts, you need a strong legal regime, legal and regulatory regime. They have to be strong, because before you even sign a contract, there should be petroleum laws in your country that can actually allow governments to enter into these contracts. And then there should be environmental laws, because whereas you have environmental provisions like we have seen in this agreement, you also need environmental laws. And then the other important thing is, often we see that developing countries in Africa, the legal framework is good, but the institution framework is very weak. If the institutions are not strong enough to even enforce the laws, to enforce the environmental laws, then what exactly are we working on? So we need to ensure that the legal framework is strong. We need to ensure that the institution framework is strong. We also need to ensure that all the clauses are negotiated in an effective and sustainable manner. And the most important thing is we need to adopt a holistic and forward-looking approach whereby governments and investors can be able to negotiate contracts that are holistic, that are also forward-looking, because yes, the extractive resources and projects are for a very long period of time, but there are always innovations, there are always changes. Initially, obviously, issues of climate were very important, or the environment were very important, but now we're also in the climate change era, implying that the way that contracts were being negotiated previously has to change. We actually have a book on renegotiating extractive industries for the energy transition. So we have to be in a position where we are evolving, taking into consideration all the different developments that are going on in different countries or even globally. So basically, that's all I have to say. But like we have seen, we're seeing lots of disputes rising across the globe from Latin America. In Libya previously, there were lots of expropriation. And then we're seeing cases in Guyana, also Guinea for the mining sector, Tanzania for the mining sector. But all this is due to first, poor negotiation skills, poorly negotiated contracts, in that after a decade or 2 decades, the government will be like, what exactly did we negotiate? What's this? So the starting point is to negotiate good contracts and provisions for both the government, investors, and the citizens. And then also to ensure that we have strong legal frameworks, and the institution frameworks and institutions also have to be strong enough to enforce the already available laws. So Christopher, I'll stop there for now, and then I can be able to take questions.
Thank you very much, Dr. Victoria Nalule, for that very comprehensive addition to the foundation set by our initial presenters. And thank you for the very practical hands-on the visual presentation of the kind of clauses we need to be aware of as we negotiate things about stabilization and sovereign risk. I know Dr. Carol Knuckle is supposed to log off for some other engagement, but I quickly want to invite her if she could give us some of her thoughts to the questions we have in the chat. And Dr. Carol, if you allow me, I'll just read the first 2 questions and we get your initial reactions as you sum up. And the first question we have is, what happens in situations where the FDI contracts are entered into illegally, i.e. in breach of anti-corruption or anti-bribery laws? Do the stabilization clauses still apply? If you can take that first.
Well, yeah, I will not do justice to the answers because I have to switch off just in really 2 minutes. But I don't know, I'm not a lawyer, but I think just from the looking at the question, if a contract is illegal, then no provisions would apply, full stop, because it's illegal. So how can you take a government to international arbitration because they broke the stabilization provision if if the premises are wrong? But that's my immediate reaction. I'd be completely wrong. And again, it depends. On the second question, if it's okay, I looked at it very quickly. When we draw the line between protecting investor and the need for evolution of government policy, how do we balance those two? This goes into exactly through it relates to what I said earlier, that you should not have blanket provisions. You should definitely not cover environmental clauses. It was in the contract whereby you limit government action from implementing changes to environmental rules in that contract. And the same thing like labor law or other legislation, that is completely wrong. There must be a way, if stabilization provisions were to be offered, they have to be very well designed and targeted. For example, you can stabilize the royalty rate for the duration of the contract. You can do economic equilibrium, whereby you say that you don't specify what exactly needs to change the same, but you say if the conditions change drastically in a way that significantly alter the economics of the contract as was initially signed, then the two parties come and discuss in good faith how to restore that balance, if not exactly, but as close as possible to that balance. But I wouldn't include environmental laws, labor laws, any legislation that goes beyond the specificities of the term of the contract on the economic side or the fiscal side. I'm sorry, the third question is too long and I won't be able to read it or to go to the detail, but allow me first of all to thank you once again for having me with you. And to all those who have questions to me, you can reach me on Crystal Energy's website. You can drop us an email, or you can find me on social media on LinkedIn. Get in touch and I'll be very happy to pursue the conversation with you. I'm so sorry, but because of the madness in the Middle East, you can imagine how our schedule look like these days. Just follow oil prices and then you can tell. But thank you very much for your time. Christopher, thank you very much. Victoria, also thank you for bringing me on board and to this very important discussion. I wish you all the best. Take care.
Thank you very much, Dr. Carol. We really appreciate you having time for us and for the very intellectual discussions you've shared with the participants.
Thank
As
you.
Dr. Carol has said, we'll release you. Thank you very much. You can reach her, and we'll also be sharing the links to her website and for further discussions if anything is not sufficiently addressed. But allow me to come back to you, Dr. Nalule, on the third question, which is, of course, quite comprehensive. I don't know if you want me to read it or you'll just react to it from your end.
I think you can read it. Let me have a look.
All right. So the third question we have is from Michael Namanya, and he notes that the insights on the impact, he notes that the discussion is dependent on two things: the asymmetry of power, as stated by Dr. Carroll, and how best to negotiate the mammoth entities with much more experience and expertise in the sector. But also correlated is the issue of transparency or lack thereof, and sometimes executed by governments, especially in the oil and gas sector in Uganda. So the question is, what would you say, or how best can we position ourselves, especially as human rights leaning lawyer, to better position themselves to support contract transparency, better deals in the interest of the people, and natural resource governance? How do we overcome this asymmetry?
All right. I think he's asking about how they can position themselves as human rights lawyers to ensure that they make better deals for themselves and also support contract transparency. So most countries are already required to make their contracts transparent and also accessible to the public, because with the extractive resources, the starting point is to understand that these resources belong to the citizens. So as a citizen, and that's your resource, you have the right to know how the resources are being utilized. And also you have a right to know how much revenue you're getting from the resources. And you have a right to know how that revenue is being used in your country. Is it being used for developmental purposes, or is the money being wasted through corruption and bribery? All those are the issues we always talk about in the extractive industries. The fact that the resources belong to the citizens and the government is just a custodian of those resources, as a human rights lawyer or for the participants out there, you already have a right to request for transparency and accountability as it relates to the governance of your own resources. So once you know your rights, then find better avenues of how you can actually execute those rights, or even ask for information that is relevant to you as a citizen. But also to note, most countries are now joining the Extractive Industry Transparency Initiative, and there is already data available on their website for the EITI about the resources in the member states of that EITI, and also the revenue that is being generated. But now the question for the citizens that is very relevant is, how exactly is this revenue being used in the country? Is it being used to construct hospitals? Is it being used to improve on the transportation sector? Is it being used to ensure that there's development in the country? How exactly is it being used? So those are the key questions that you have to ask yourself, especially for the gentleman who has mentioned that they are human rights lawyers. Yeah.
Thank you for the response, Dr. Nalule. We have another question from Meshak Mboya. He says, after the ICJ advisory opinion on state duties to protect climate system and also specifically the finding that fossil fuel licensing can be construed as a breach of this duty, what is the policy space to cancel fossil fuel contracts altogether?
It wouldn't be advisable to cancel fossil fuel contracts because obviously, like the contract, the example of the contract I've shared with you, once you do that, then the investor will have to bring a dispute in international arbitration because you have already committed as a government to really go through with this contract. But what can be done, because obviously, like I mentioned, we are in the climate change era and energy transition era. What can be done is to ensure that there are strong environmental provisions in the contracts, and even there are strong environmental laws so that, because we already know that fossil fuels basically contribute over 60% of the greenhouse gas emissions. But the question is, how can you mitigate on those emissions? Can you request investors to employ clean technologies like carbon capture? Can you request investors to follow the polluter pays principle whereby they're paying for their pollution? All those are mechanisms of how you can mitigate the greenhouse gas emissions or the emissions that are coming from the fossil fuel sector. Otherwise, a government can't just wake up to cancel contracts where they have already committed and they decide to cancel it without reasonable grounds. If they do that, they will pay heavily under arbitration, international arbitration. Christopher, I also have to leave, I'm afraid, but for those interested in my books and articles, you can find them on on our website for Name Energy, and also connect with us on social media.
Well, thank you very much. I have to say there are many questions. I'm seeing a lot of queries still coming in our chats, but we'll share this with the presenters and hopefully get a way of responding to all the participants who have some additional questions. I've also seen people asking for your links for your websites. I believe Gabriel from the ELS will be able to share that. So at this point, Dr. Nalule, we just want to say thank you very much once again for the time you spent with us to discuss this very important topic. I know there are a number of issues that are still worrying in the global energy extractive market. The Iran issue, a lot of issues in the Middle East, which if we had more time, perhaps we'd have received more of your insights on that. But thank you once again for your time and the presentation and the discussion you've had with us here. At this point, I would like to invite Gabriel from the East African Law Society, maybe to give the final remarks as we wind up.
Well, I would like to thank you, Christopher, for moderating this wonderful 1 hour session. It's been 1 hour, quite impactful, and it's left us yearning for more. So, Dr. Victoria, I think we need to plan to have a follow-up session of this. As you can see, the questions are still streaming in. There are quite a number of them. And as such, we will gather all the questions in this chat and get to share them with our respective panelists. We'd like to thank the good Prof and Doc for hopping onto the session. It's been quite lovely learning from them. And colleagues will have a second session discussing this very topical issue. I know we've set the ball rolling, and now with the Iran crisis, I know Christopher were discussing this the other day to organize that soon and share a link. Otherwise, on behalf of the entire Secretariat, our President, our CEO, Mr. Ghana, I would like to thank you all for wonderful collaboration. For asking name Energies, it is NE Energies. You can visit their website for delivering most of these sessions. I'd like to thank you and wish you all a very lovely afternoon ahead of you. And we hope to catch you again on Thursday as we you. From us, you wish you a very lovely week ahead and a very lovely afternoon ahead. Thank you, and you can now all exit at pleasure. Goodbye.
Thank you very much, Gabriel.